My question is for the Attorney-General. Back in October 2020, I asked the Minister Carroll whether the regulator of the commercial passenger vehicle industry has acted as a model litigant during the recent Supreme Court proceedings with the taxi and hire car families. I received no reply despite the standing orders requiring all legitimate questions to be answered within 30 days. After 3.5 years of litigation costing taxpayers what looks like or close to $1 million, the Supreme Court has ordered the regulator to release the documents for preliminary discovery and pay 80% of the taxi and hire car families' legal costs. Information that no doubt could have been released by the regulator under the Freedom of Information Act. Attorney, if there is nothing to hide nor any reason to cause reasonable delay, is the regulator's action that of a model litigant?
Thank you, President, and I thank Mr Barton for his question and his ongoing advocacy for taxi families and, of course, using the House as an opportunity to raise these important issues. It's a little difficult for me to respond in a lot of detail to the questions that you've asked. I'm more than happy to follow up with Minister Carroll in relation to that element of your question. You're also technically asking me for opinion, so I might just give some general comments in relation to model litigants. So the Department of Justice and Community Safety, they have guidelines on the obligations of the state, its departments and its agencies to act as model litigants. All governments around Australia also have a common law responsibility to act as model litigants. Victorian departments and agencies have a duty to behave as a model litigant in the conduct of all of their litigation. And as I said, it's not really appropriate for me to comment or give an opinion in this case. It's not something that I want to get into the practice of commenting on individual cases, whether they are before the courts or indeed have been before the courts. But as I said, important issues that you raise, I know it's an important court case and ongoing issues that taxi families are facing, and I'll follow up with Mr Carroll in relation to any outstanding matters.
Supplementary, Mr Barton.
Thank you, Minister. As the courts have firmly held since 1912, it is an expectation that state and its agencies will act as a model litigants. That is, that they will act with propriety, fairly and to the highest professional standards possible. In particular, the model litigant guidelines also include the state and its agencies, and to keep litigation costs to a minimum and to deal with claims promptly so not to cause any unnecessary delay. Considering those factors and the way the regulators acted over the past 3 years, I ask the Attorney, who is responsible to ensure the agencies are acting as model litigants?
President, I thank Mr Barton for his supplementary question, and as Attorney-General it is certainly my expectation that all government agencies act as model litigants in relation to the specific responsibility of agencies and departments in how they conduct their litigation practices as a matter for individual departments.